law has become so much part of our life that we are encountering law every day while driving. I was, hearing about the challans when we are renting our apartments or we are dealing with the other people. So laws are the rules by which we live. So the moment we open the newspaper, we come across so many articles talking about legalization of marriage, same-sex marriage, legalization of abortions, latest prosecutions. So in this entire scenario, it becomes very, very essential for everyone to have at least basic understandings of the law so that one can evaluate such issues in a very, very effective manner. So I'm very sure that this program would prove to be very, very beneficial for all our learned participants who are from different colleges on Delhi University, as well as I think it's from the Delhi University only. So since I'm a criminal law teacher, and I'm given an opportunity to discuss law of crimes with you all. Law of crimes is very, very wide. It's consist of IPC, it is consisting of CRPC. And so today I thought of, dwelling into the criminal procedure code, because I was really thinking, which topic I should prepare for the kind of the audience we are having. And then I realized, what happens most of the time is that we are not aware of the processes which are followed in the court of law when we are accused of we are accused of committing some offense. So what are our entitlements as an accused? If any offense is committed against us, if we are the witness, so if we are the victim, so what are the kinds of the protections which we are entitled to? So I thought it relevant to discuss the procedures which are followed in the courts of law, starting from FIR to the final judgment, coming to appeal, revision, and reference. And I would be in this particular session, I would be familiarizing you all with, of course, introduction to the law of crimes, giving you the how, to what extent what is the nature of this procedural law and substantive law, which we are having under the umbrella of criminal law. And so at the same time, I'll be familiarizing you with the concept of FIR, the stages involved in its investigation, then filing of challan. There's a charge sheet that's different from the challan under the Motor Vehicle Act, which we were talking about. And I'll be also be referring to the latest amendments, latest reforms that have been made, just with a view to protect the human rights from the victim's perspective, from the witness perspective, from the accused perspectives. Sorry. Okay. Am I audible?
Yes, you are audible.
Yeah. Okay. Thank you. So, this is the way I have structured my presentation.
I think बहुत सारी चीजें हैं, ये इतना करिए, फिर उसके बाद बात करते हैं.
I request Ritu, please mute yourself. Yes, continue, ma'am.
So this is the kind of the structure I have kept for today's presentation. I was hearing about the sexual harassment also, but I have not made a sexual harassment as a part of my presentation, because I was actually thinking that so far when it comes to sexual harassment in each and every college, sexual harassment lectures are being organized as a part of NAC requirement. So I thought of covering the procedural laws to make you all aware of the procedures to be followed in the courts of law, and to make you aware of your entitlements in case you are accused of an offense, in case you are the victim, in case you are the witness. So I would like to share the presentation with you all. And later on, when I wind up this session, the questions will be most welcome from all of you. So just give me a second to share my PPT with you all.
Ritu, please mute yourself. Ritu, please mute yourself. Okay. Yes, ma'am. Continue.
Is it visible on the screen?
Yes, it's visible.
Okay. Thank you so much. So as I told you, the purpose how I am going to today deal with this particular law of crimes. So as I told you, first of all, it is very essential for me to introduce you to this concept of law of crimes. And as the name is suggesting, law of crimes is the law that governs the prevention of the offenses, and it prescribes punishments to those who commit those offenses. Law of crimes has two parts. One is substantive, that defines offenses and prescribe punishments. I'm talking about Indian Penal
Sorry
Code.
to interrupt, ma'am.
Yeah.
If it is in presentation mode, that would be more easy for us to view.
Okay, just a second. I am not very good with the PPTs because usually we teach by the lecture method. Is it
No, no, it is still in that.
I'm really not good with
Otherwise,
the.
it's okay. Otherwise, it's okay. It's okay.
Okay, so you guys can see it on the screen, isn't it? Is it visible or not?
Visible.
Okay,
It's visible.
so substantive law is our IPC, which we all are aware of. Every day in the newspapers, we come across different kinds of offenses. And so far, this IPC is concerned. Broadly, if you look at the IPC, it has 511 sections, and it is divided into two parts broadly. One is the general principles, which talks about explanations, exceptions, uh, definitions are there. Then uh, abetment, attempt, and then there are specific offenses against body, offenses against property, offenses related to marriage, offenses related to defamation of against the state. And from time to time, there have a lot of been amendments have been made. You all are aware of how a lot of amendments have been made to the offense of rape. So a lot of amendments have been made from time to time to make it more progressive, to adjust the flux of changes that are happening in the society. Then we have a procedural part, which defines, which prescribes for the procedures to be followed in the courts of law, to be followed at the time of investigation, inquiry, trial. So this CRPC provides all these procedures. It regulates the machinery, working of various machineries, namely police, court, prosecutors. It provides for apprehension of, detection of crime, apprehension of accused persons, collection of evidences, determination of guilt. And there used to be an act of 1898. Before this CRPC 1973, there used to be 1898 code, which was repealed by the CRPC 1973. And why it was repealed? Because there was a lot of lacunas which were being highlighted by the law commission. If I just give you an example, it was not containing much provisions related to fair trial from the perspective of the accused persons. There was no concept of probation. There was no concept of anticipatory bail. So a lot of recommendations were being made to make it uh, fair, in order to make the entire trial very fair in accordance with the principles of natural justice. So it was replaced by 1973 code. It retained many of the provisions, but at the same time, many new provisions were also being introduced. And again, from 78 to 2018, a lot of amendments have been made to the CRPC also. So the criminal law of the land is consist of your IPC, CRPC, and Evidence Act. These are the three legislations which are seen together whenever the criminal proceedings are going on. In case if the offense is with respect to the IPC only, fine. So in case it is with respect to any other criminal legislation, there are a lot of special legislation. POXO is there. NDPS is there, FEMA is there. So special economic welfare legislations are there. So it depends on what kind of legislation, but the combination of CRPC and evidence remains there unless and until the particular special legislation prohibits the same, and it provides for its own procedure. So I'll get into the same later on. So we are talking about this CRPC. So one thing, you have come here for legal literacy. So I thought it one thing very, very interesting to tell you all. Whenever you look at any kind of legislation, any kind of Bear Act, if you take in your hand, the very first thing you need to know is about to know the nature of the particular enactment. And how you're going to know it is, please always look at the preamble carefully. And if any enactment is using the word consolidated anywhere in the preamble, always remember it would be completing, it will be indicating at the completeness of that particular enactment. It is showing that it is an exhaustive code. So if I'm talking about CRPC, if you will look at CRPC, it is using the word consolidated in the preamble. If you will look at the Evidence Act, it is using the word consolidated. So whenever the word consolidated is being used, it is indicating the exhaustiveness of the law. And the same cases with the CRPC, which is having 484 sections, 37 chapters, and 2 schedules. Each and every situation which can possibly arise is being covered in the CRPC, but still, if any situation is not covered, then our High Court is having the inherent power under Section 482 and can modify the provision and to meet the ends of the justice. So, but that happens in very rare circumstances. Almost each and every circumstance that may possibly arise is there under the CRPC. And there are two schedules which are attached to the CRPC. Schedule 1, it's talking about tabular statement of offenses under IPC. The moment you look at that schedule, you will find different columns are there, which with the one column will be providing you the definition, section, then punishment, then by whom it is compoundable, what is the nature, it's a bailable, non-bailable, by which court it can be tried. So that kind of description, which is usually there in the IPC, below any offense, there is always a classification in the IPC. The same uh, version is being given in the IPC. The very summary version kind of, all offenses of IPC is given at the end of the CRPC. And then it contains 56 drafts, schedule 2. Yeah.
Harleen, I'm extremely sorry, but this is just asking you in terms of how to set the tone. चूंकि बिल्कुल ही इनिशियल अंडरस्टैंडिंग हम लोगों की बन रही है आपके साथ, कुछ प्रश्न, कुछ शब्दावलियां ऐसी हैं जिन पर शायद हम लोग बिल्कुल अटक ही जाएंगे,
जी.
है ना? तो वुड इट बी ओके अगर हम चैट में उसे डाल दें, जैसे अब मैंने इंटरप्ट किया आपको, है ना?
जी, ऐसा है मैम, मैंने बिकॉज आपको बिगनिंग में बताया कि आई एम नॉट वेरी गुड एट विद द पीपीटी एंड ऑल, बिकॉज वी यूजुअली फॉलो द लेक्चर मेथड, एंड सो व्हेन आई एम शेयरिंग माय स्क्रीन आई एम नॉट एबल टू सी यू ऑल. I can't see the chat box at the time I am presenting my screen. I'm not good at minimizing the screen and looking at the chat at the same time. So that is why, I mean, orally you can ask me, that's not a problem to me. Okay. Or at the end of, you can keep your queries reserved, and at the end, when the moment I'll be ending my lecture, you can whichever way you are comfortable. I really have no issues with it.
Ma'am,
Dr. Preeti, I think हम ना open session daily plan है हमारा. So towards the end of the day's session, you can surely ask, or you can write in chat box. We'll help Dr. Harleen to answer those questions. Whosoever would be concluding the day out of our ILLL team would be surely taking up those questions with Dr. Harleen.
Once I'll done with the presentation, I'll definitely be taking all the questions from the chat box itself.
Yeah. In between, if we'll make it interactive, then a lot of time will go into it and presentation will remain incomplete.
Yeah.
Thank you, Professor Arora. I also request you to that please start the recording of this session. So in case someone missed that, they can see it on the YouTube channel of the ILLL also.
Even yesterday, we confirmed that all sessions are being recorded. Don't worry.
Okay, thank you.
Okay, thank you. So I think I should continue with my presentation. Okay, so I was just telling you that, the second schedule, I'm just, first of all, so I hope this consolidation is definitely going to help you to understand the nature of a particular enactment, whether you need to see any other enactment in combination with that particular enactment, or that enactment itself is a complete enactment. So that is a schedule 2, where one can see the draft of, bail bond, search warrant, arrest warrant. So different, how the charge sheet is, how the challan is being, the charges are being framed by the magistrate. So all kinds of drafts are there. Bail bond drafts is there. Now, as I told you, that CRPC 1973 replaced this 1898 code with an object to ensure fair trial in accordance with the accepted principles of natural justice, to avoid delay in investigation, trial, and sentencing. Though, despite of those provisions, we all know the reality that there have been huge pendency of criminal cases in our system. But nevertheless, we have adopted some ADR techniques also, and but it's just probably because of the lack of infrastructures and less number of the judges, we do have such kind of issue still prevailing. So this basically it is mainly procedural in nature. I am not saying purely procedural in nature. Again, I'm not saying it's a purely procedural in nature. The reason is that one can come across certain substantive provisions also, like, right of maintenance that is given to the children and parents under this section 125 of the CRPC. It is applicable to every person irrespective of the religion. And one can see the right to appeal that has been given to the victim also under this the CRPC. So it is also substantive in nature. One can see the provisions related to asking for the security for keeping peace and maintaining tranquility. So these are some provisions. And one very important thing for you to know is that the CRPC is a subject matter in concurrent list where both state and center can amend the same. And so wherever the state is amending any of the provision of the CRPC, that amended provision is going to have effect in that particular state. If I give you an example, if you are aware that in UP there was no concept of anticipatory bail. It used to be there, but when emergency was proclaimed in 1976, it was revoked for the purpose of securing arrest and detention of the political opponents. So at that time, it was revoked. And after that, what was the scenario? That the people, whenever they were having, any FIR was registered against them, and they were having an apprehension of getting arrested, they had to secure stay on arrest from the Allahabad High Court. So it's only after 43 years in 2019, only again it got reincorporated in the UP. So one can see that since state can also amend the CRPC, so wherever, and the moment you will look at the CRPC, one can come across certain amendments which have been made by the states, and those amended provisions are having the application. Then another thing becomes very essential is for me to tell you is that we talk about law of crimes. You must hear law, criminal law. But the thing is that, the crime term which we use in context of law of crimes, it's a very, very relative concept. There's no precise definition of the term crime. If you ask me, being a law teacher, that what is meant by the term crime, uh, it doesn't have any precise definition. It's an act against state. It's an act forbidden by law. It's an act against the moral sentiments of the people. It's an basically against the standards which are set by the law. So when we relate it with law, when we relate it with morality, law and morality are something which keep on changing from time to time. So what is crime today may not be a crime tomorrow, and what is an example can be a perfect example of homosexuality used to be crime, today it is not. Adultery used to be crime, today it is not. Abetment to suicide is still a crime, but passive euthanasia has been allowed. And in fact, the courts have also allowed making of the living wills in the case of Common Cause versus Union of India. So things have been changing. But one thing is there are certain acts which are always been unacceptable by any society, but the way the society has punished those crimes, that concept has got changed with the time, and new branches have emerged: criminology, penology, victimology. So with criminal law today, you can see many more branches. Criminology, which is more interested in knowing what leads the person to a criminal behavior. It focuses on the reformation of the offender. Penology, again, that's talking about reformation of the prisoner. Then we have victimology, which brings a victim at the center stage. And today, the victim is not a forgotten person. And they basically try to reflect a victim and the offender as a penal couple. So, with different branches of the studies which have emerged, the way we have always punished our offenses have changed, and today we have started journey from a deterrent theories towards reformative theories, fine. So that change can be seen, but the word crime you will not find anywhere in the IPC or in criminal law. It is a word offense that is being used. And if we need to look into difference between crime and offense, people will say it is synonym. They are interchangeable, but yeah, at a broader level, differences there. We can say crime is a genus and offense is a species. Crime is a much, much broader term as related to term offense, and the word offense is used in IPC and the CRPC. And how this offense is being classified in both these substantive and procedural criminal law, One can come across cognizable and non-cognizable offenses. One can come across bailable and non-bailable offenses, compoundable and non-compoundable offenses. So when we talk about cognizable offenses, police officer can arrest you without warrant. Police officer doesn't need any kind of permission for investigation. Cognizable offenses are all your serious offenses, uh, which are of like murder, dacoity, robbery. And sometimes, when we differentiate cognizable and non-cognizable, we also tell our students that, punishment is also something that can be seen. All offenses more than 2 years are usually cognizable in nature if you look at the IPC. But that is not a hard and fast rule. Forming unlawful assembly, just forming unlawful assembly, forming an assembly is your constitutional right. But if you form an assembly for unlawful purpose, it becomes unlawful assembly. That forming itself is a punishment. It's an offense punishable with 6 months imprisonment. And if you are being armed with weapon and you do rioting, then it gets aggravated and the nature of the offense gets changed. But forming unlawful assembly, which is against state, which is less than 6 months punishable, still it is being made cognizable. So the major difference between cognizable non-cognizable is on the basis of investigation. That how in non-cognizable, no police can arrest you without warrant. They can't do investigation without the permission of the magistrate, and less serious offenses are considered to be non-cognizable offenses. Then we have a bailable and non-bailable offenses, where bailable offenses where you can claim bail as a matter of right. The moment you are arrested, the police officer has been given under the CRPC the power to grant you the bail. You don't need to reach to the court, because in bailable offenses, usually you are always been granted bail. But in non-bailable offense, police has no power to grant you bail. It is only the court which is going to grant you the bail. And after taking into consideration certain factors: nature of the offense, severity of sentence, possibility of tampering, possibility of absconding. So all these factors are being taken: protracted nature of trial, how long the trial is going to take, antecedent of the accused person. So all these parameters are being taken into consideration by the court, and it's a matter of discretion of the court to grant you bail in a non-bailable offense or not. And in offenses like murder, it's only court of session which can grant you the bail, because every court has its own power of sentencing and giving in sentence and punishment. So I'll be referring to that also. And then we have a compoundable and non-compoundable offenses. We were talking about challan. That's something that is compoundable under Motor Vehicles Act. You can pay there only. And similarly, certain offenses in the IPC are not considered to be very serious offenses. So they have been made compoundable by the parties themselves. Like if somebody restrained you, and hurt cases. So the simple cases are compoundable, but some cases can only be compoundable with the permission of the court. 420 ho gaya, grievous hurt ho gaya, so they can only be compounded with the permission of the court. So that's how the section 320 of the CRPC provides for compoundable and non-compoundable. But there are certain offenses which are serious in offenses, they are not compoundable. So they cannot be compounded by in any circumstances. The kind of, again, it's very essential for us to know what kind of criminal justice system we are having in India. It is adversarial in nature. You must have seen people rushing to the big lawyers for getting their case argued by them. Why this is so? This is because of the reason that our system relies heavily on the skill of the lawyers, and the lawyers present arguments. Judge is just an umpire. He's just very neutral. He's just listening to the arguments, and he's looking into the evidences brought on record. He can't decide the matter on the basis of his own satisfaction. He just has to see whether the things have been proved beyond reasonable doubt or not. So judge has no active role to play in finding the truth in our system. Whereas we compare it with inquisitorial system, which is followed in countries like France, Germany, there the court itself makes very, very genuine efforts to find out the truth. Cases are being heard every day without any adjournment, but this is not the case in our system. And there the judge can decide on the basis of his own satisfaction and doesn't need to see whether the things have been proved beyond reasonable doubt or not. And because in our system we believe in proving the things beyond reasonable doubt, so the prosecutor is under the burden to prove the things beyond reasonable doubt, because our system is based on a presumption of innocence on the part of the accused person. And why we have this provision of proving the things beyond reasonable doubt? One very basic reason which we have is, in our country, we all know once somebody has been convicted, he carries that stigma of conviction with him. So there is no such provision of providing clean chit to a person, after serving many years of sentence. Still, we do not have this kind of provision in our country. Whereas if you go to Germany, you will find that after 5 years, a person is being given the clean chit. We do not have that. So because convictions brings a stigma of disqualification from the government services, and other demerits are there. Therefore our system requires the things to be proved beyond reasonable doubt, and that the burden is on the prosecutor. But if we look at the accused person, he is just required to show the existence of probabilities in his favor. So if a person has killed somebody, the prosecutor has to prove that it has been something that has been that person has been killed with guilty mind, and that has to be proved beyond reasonable doubt. And one very interesting thing, if I tell you, I told you that Evidence Act is also to be seen together with this criminal system, in the criminal system. And there was a time when the prosecutor was not only under the burden of proving, this person has killed somebody with the mansoria, he was also supposed to prove it beyond reasonable doubt that this killing was not done in a right of private defense. This killing was not done in exercise of, doing some good faith. It was not done under accident. So he had an additional burden of proving that. But when the Evidence Act 1872 came, because IPC is 1860, evidence is 1872. When evidence came into enactment, there is a section 106 of Evidence Act which makes it very clear that unless and until those circumstances are brought within the knowledge of the court is going to presume the absence of those circumstances. So what does it mean? Now the prosecutor is just required to prove the things, that this person has killed a person with a mens rea, and once he proves it, the burden shifts on to the accused person, and now he has to just show up, cast a doubt on the story of prosecution. And once he's successful in doing so, he is not going to be convicted. So that's how the game will, keep on shifting. So this is a kind of a burden of proof on the accused. And now it is for the accused to say that I did a killing, but I did this killing under right of private defense. And once he can show the probability existing in his favor, he would succeed. So the basis of criminal liability in our system is actus, very well-known maxim, actus non facit reum nisi mensit rea. An act alone is not guilty unless accompanied by a guilty mind. So what does it mean? It means if I am killing somebody, I'm a doctor, I performed an operation knowingly, it was very risky, but I did it in good faith to prevent his life, and this resulted in causing death of a person. This act would not make me guilty. Why? Because I never had a mens rea, I never had intention to kill. This is not something that has been done in negligence. I did it with a view to protect his life. And similarly, any intention which is not followed by any act can never make you liable for any offense. If I have an intention to kill somebody and I buy a poison and I'm caught with that poison, the question arises, can I be held liable at this stage? Answer is no, because it's very difficult to prove for what purpose I have purchased a poison. So unless and until I do not do anything with that poison, if I do not move forward with any step, how can you make me liable? Because intention is something which is subjective. This is in there, your mind. And how it is to be proved? It is proved by the act which is done in furtherance of that intention. So actus reus plus mens rea. This is a very, very important base of criminal liability in our system. But yes, exceptions are there. If I am saying that only mens rea can't make you liable, it can make you liable. Where? In case of dacoity, in case of conspiracy. So in case of offenses against state, you're found to be in possession of counterfeiting notes and coins, though you have not used it, but you are going to be held liable. But you can see exception is there, where you can be held liable for preparation stage, but that will be only with respect to the offenses against the state. This is how is the scheme of the IPC. So generally, it is the actus reus and mens rea, which both have to be seen together. Now, who are the stakeholders involved in our system? Police, prosecutor, defense counsels, prisoner authorities, witness, victims, courts. CRPC doesn't provide for any constitution of police. It's governed by Police Act. CRPC only presumes the presence of the police and confers wide power on the police from investigation, arrest, detention, everything. Then we have prosecutors. State is represented by the special lawyers called public prosecutors, additional public prosecutors in the higher courts, and assistant public prosecutors in the magisterial courts. Then we believe that no person should be condemned unheard basis of principle of natural justice. So we provide our accused a lawyer to be pleaded by the lawyer of his own choice. And if he doesn't have the means, state is going to provide the lawyer. Then the prison authorities. Again, our constitution doesn't provide for a constitution of prison authorities. They are governed by Prisons Act. They are governed by the Prisoners Act. Fine. Uh, every state has its own state, state jail is having a state manual, jail manual hota hai har state ka apna apna. So they deal with how they will be dealing with the prisoners and also that's in virtue in that is taking its authority from the central legislation on the Prisoners Act. So again, they play very important role. Witness considered to be eyes and ears, but unfortunately you will not come across any definition of witness in the CRPC, nor you will come across any provision talking about the protection of witness. That's the something which is very unfortunate, but with the time reforms have been made, so I'll draw your attention to that particular reforms also. Victims, they said they are the one who set the criminal law into motion, so there are certain sections which are dealing with rehabilitation and compensation of the victims. Then we have courts. Supreme Court is at the top. Then we have High Court, can pass any sentence. We have Court of Sessions, consisting of session judge, additional session judge, can give any sentence, but that sentence requires confirmation from the High Court. And for division of work, there is an assistant session judge also, and that can give imprisonment up to 10 years. And then we, go with a classification. We have metropolitan areas, fine, Delhi, Bombay. So where the population exceeds 1 million, there we have chief metropolitan magistrates. And in districts like Ghaziabad, we have CJM, Chief Judicial Magistrate. Their powers are same. Both can give imprisonment up to 7 years. Then below them, we have metropolitan magistrates. Districts में judicial magistrate one होता है, first class. That's they both can give imprisonment up to 3 years. Then in district, there is a JM2 also. Then he can give imprisonment up to 1 year. And then we have executive magistrates in both the metropolitan areas and district. Executive magistrates are your SDMs, your district magistrates, your deputy commissioners जो होते हैं, तहसीलदार जो होते हैं, they all fall in this category of executive magistrates. So this is a kind of the hierarchy. A lot of sections are being dedicated to the constitution of the court because CRPC provides for the constitution of the courts, create different grades of the courts, confer them with different punishment. So a lot of sections are there in the CRPC, section 6 to 18 and 28 to 30, dealing with the sentencing and the hierarchy of the criminal courts. Now, most important for us, stages involved from FIR to the judgment. Fine. FIR, investigation, charge sheet, cognizance, framing of charges, trial, judgment, appeal. So I'll getting into all these in detail. Now, with respect to non-cognizable offense, if somebody commits a non-cognizable offense like cheating against you, the what kind of, if you're going to police station giving information to the police officer, that information is going to known as non-cognizable report. And I told you that no officer can do investigation in non-cognizable offense without the permission of the magistrate. Nobody can arrest without the permission of the magistrate. So in non-cognizable report, whenever it is being recorded, it is being sent to the magistrate and it is sent for the purposes of asking his permission to do the investigation. And in case if the arrest is required, to seek his permission in case of arrest also. And when it is with respect to the cognizable offense like murder, dacoity, robbery, it is known as first information report. That is the information which is first in point of time, that is called FIR. And by whom it can be made? It can be made by any complaint victim, any person on his behalf. It can be made by any passerby also, who doesn't know who is the victim, who is the person who has killed him. But what he should disclose it to the police, he must disclose the commission of a cognizable offense. So that's a mandatory requirement. Any information which is not disclosing commission of cognizable offense, police will never register it as an FIR. And there is a section 154 in the CRPC which says any information given orally to the police has to be reduced in writing, needs to be signed by the informant, needs to be read over to the informant, and the copies to be given to the informant, and the gist of the same. Police stations maintain a general diary. police stations maintain a cognizable offense register, non-cognizable offense register, and a journal diary where they record everyday complaints in that journal diary. Fine, these days things have been it's a time of technology, so nowadays they don't maintain registers anymore, they maintain data in their computers only, but this is the way they maintain the records. So section 154 makes it how and in what manner the FIR has to be recorded. But one thing you must know, that once any information discloses commission of cognizable offense, it has to be recorded in by the police officer, and he cannot refuse to do so. But there is a Lalita Kumari judgment which has made it very clear. If he refuses to do so, then a disciplinary action can be taken against him. You have section 166A in the IPC, where he can be made punishable with the imprisonment that go to 6 months up to 2 years. But at the same time, the Lalita Kumari judgment, which is a leading judgment on FIR, has also made certain exceptions that, the police officer can conduct preliminary inquiry in certain cases, not exceeding 15 days if it's a corruption cases. If it's a medical negligence cases, अभी आपने पीछे में पढ़ा होगा डॉक्टर्स को लाइबल कर देते हैं. So, just to prevent unnecessary harassment, unless and until some expert opinion is not sought, whether it's actually a case of medical negligence, so, it's not considered to be recommended that the doctor should be arrested. So in medical negligence cases, corruption cases, commercial cases, cases of abnormal delay in lodging FIR, these are the cases where the police officers say that I am not going to record the FIR at right now. I'll be conducting some preliminary inquiry, but that preliminary inquiry should not exceed 15 days. In other cases, it has to be recorded. And what is the evidentiary value of this FIR in the courts of law? It's not a substantive piece of evidence. It can only be used for corroboration of the statement of the informant, or it can only be used for contradicting his statement in the courts of law. Nothing else is the purpose. Nothing is the purpose of the FIR. Now, what remedies you are having if you are accused, if somebody has committed an offense against you, and the police is saying, I am not going to register the FIR. Now, what you are going to do? You can approach the superintendent police under section 154(3), or any other officer who is above the rank of sub SHO. You can refer to superintendent police, DGP, because administration of police in states is in the hands of the DGP, and then in districts it's in the superintendent police. So accordingly, any officer can be contacted. If the grievance still persists, so superintendent is going to give the directions. If the grievance still persists, one can approach the magistrate under section 156(3). आप magistrate के पास जा सकते हैं. One can file a criminal complaint under section 200 before the magistrate, and one can rush to the High Court by filing writ petition or petition under section 482 CRPC. Now here I just want to tell you, I have highlighted this portion. Why I did so, just to make you one thing remember, that we have so many remedies in case of non-registration. So, Supreme Court has given instructions to the High Court so many times, please do not entertain writ petitions with respect to grievance of non-registration of FIR, और FIR तो register कर लिया लेकिन investigation नहीं कर रहे हैं. So Supreme Court tells High Court, please do not entertain and make sure that all alternative remedies have already been exhausted. So, so there are a lot of remedies. So one can approach that. And in case if that is of no help, then of course one can go for filing writ petition under section 482. And this is a case, and this is a time of technology. So there is also uploading of FIR these days on the website, which has to be uploaded within 24 hours, maximum 48 hours. And if there's a geographical network issue, then it is 72 hours. But in cases of sensitive offenses like insurgency, terrorism, sexual offenses, you will not find any FIR to be uploaded. तो आप चेक कीजिए, अगर आप डिस्ट्रिक्ट पुलिस की वेबसाइट पे जाएंगे तो वहाँ पे बिल्कुल आपको उसमें आता है the FIR you want to see, you can put the name of accused or you can put the name of the victim, and that is how you will get a relevant information about this FIR. And this direction of uploading was given in a very, very leading judgment, again, Youth Bar Association versus Union of India, where it was said that whenever the criminal law is set into motion, the liberty of a person is at stake. So everybody should be knowing what is the FIR against him so that he can take necessary action. So that's one of the endeavor to make a person aware of whenever there is a threat to his rights. आपने zero FIR भी सुना होगा, zero FIR भी use करते हैं. Offense is committed at a place, you approach the police station officer बोलता है हमारे jurisdiction में नहीं है, आपकी jurisdiction किसी और पुलिस थाने में बनती है. So once your information is disclosing cognizable offense, I told you by the virtue of Lalita Kumari, now they can't refuse to register the FIR, but that FIR is called zero FIR. And that zero FIR is transferred to the concerned police station, which is having a jurisdiction to investigate that offense. So that FIR is called zero FIR. So there's no provision in the CRPC as such dealing with zero FIR, but this is how we understand by zero FIR. That is the name given to the FIR that is recorded by the station having no power. Then after FIR, now once the FIR is done, now comes the state of investigation, which is exclusive domain of the police. Court doesn't interfere, magistrate doesn't control. मैंने आपको पहले beginning में बोला था, the kind of a system we are having, the courts do not make any efforts to interfere anywhere unless and until some kind of prejudice has been caused and that has been brought before the knowledge of the court. So investigation is the exclusive domain of the police under CRPC. It includes proceeding to spot, collecting of evidences, search, seizure, arrest, examination of witnesses, collection of evidence. But whenever police does an arrest, it is also essential for you to know that this arrest is defined in the CRPC as actually touching a body of a person, confining the body of a person. No women can be arrested after sunset before sunrise, but the section 46 authorizes the police to make use of the force for the purpose of making arrest, but that force cannot be used to cause the death of a person. While arresting, you can't cause the death of a person who has not done any offense punishable with death or life imprisonment. बट अगेन यू ऑल नो जुडिशियल एक्स्ट्रा जुडिशियल किलिंग्स तो हम सबको ही मालूम है, चाहे आप हैदराबाद का केस देख लीजिए, चाहे आप कोई सा भी केस देख लीजिए, देयर हैव बीन मेनी ओकेजन्स ऑन विच द पुलिस टेक law in their hands and they do the justice there then and there only, but that has not been much appreciated. It's a difference of opinion is there amongst the public. So but nobody comes against those police officers and depose in the courts of law that how they have exercised their powers in an arbitrary or illegal manner. So fake encounters, Vikas Dubey ke case mein, so they have no justifications. The reason is these officers are not being held liable because nobody comes, subordinate doesn't come in front and depose against his superior officer. So but there are the guidelines how in a manner the arrest is to be made, and the maximum period once arrest is made, a person can be kept in the custody is police custody not exceeding 15 days. The moment you are arrested, you have to be produced before the magistrate within 24 hours. And if a police say that I need to do further investigation and I require the custody of this person, the maximum period to which the court would give a person in police custody would be 15 days, not exceeding 15 days. After completing 15 days, if a police says I need more detention, then it can go for 90 days in the cases offenses punishable with death, life imprisonment, or minimum 10 years and more. So three categories aa jati hain. Fine. Minimum 10 years, 20 years ho sakta hai maximum. So there are three categories where 90 days period and 60 days in all offenses punishable with maximum punishment of 10 years, up to 10 years. And if still investigation is not complete, this is a rule. And this is a rule for filing a charge sheet also, chalan, the local word that is being used for the charge sheet, that it has to be completed within 90 days and 60 days. And if it is not completed, person is entitled to default bail. There is a concept of default bail also in the CRPC, that if investigation doesn't complete in time and it's exceeding 90 days and 60 days, if you are in custody, you have a right to get released on a bail as a matter of right, and no court can refuse to grant it. And the person arrested is also entitled to many safeguards: to know the grounds of arrest, to nominate any person, right to be informed, right to bail, right to consult a legal practitioner, right to medical examination. हर 48 घंटे के बाद जेल में उनका medical examination कराया जाता है. The moment the person is arrested, he is sent for the medical examination. Why this is so? This is just to make sure कि arrest करने के time पे उसके body पे कितने marks थे, and when he was being kept in custody, whether he was subject to any torture or custodial violence by the police. So right to health and safety. And as I told you, no person can be detained more than 24 hours except the permission of the magistrate. And handcuffing is not permissible these days unless and until somebody is an habitual offender. So it is not as a matter of routine. It's considered to be very torturous. And arrest needs to be in conformity with the DK Basu guidelines. Again, a very leading judgment. By and now, all provisions, all guidelines have been part and parcel of now CRPC. But yes, police must have clear identification at the time of arresting somebody. The police must be having arrest memo signed by the witnesses. The person must be subject to examination after 48 hours. So all these right to inform, right to know the grounds, all those guidelines, which were there in DK Basu, now they are the part of entitlements, which I just talked about. And in modern times, a compensatory jurisprudence has emerged in favor of accused person also. So if there is the arrest is later on found to be illegal, so they have a right to claim compensation also, and that was being laid down in Neelavati Behera versus State of Odisha 1993. So that is why I was saying handcuffing is not permissible. Aap handcuffing karte ho, and later on, this entire, he is acquitted, and this seems to be a malicious arrest at all. So then the person is entitled to claim compensation against those police officers, and those police officers will also be liable to disciplinary action. They can be suspended. Once investigation completes within the time period I talked about, then comes the stage of filing charge sheet. And the charge sheet is filed, which is also known as चालान कहते हैं इसको कोर्ट में, local language में 173 section. And it has to be filed within 90 days and 60 days, as I told you when I was doing investigation with you. Now, once the charge sheet is filed, now comes the turn of the magistrate again, before whom it is being filed under section 190 to take the cognizance of that complaint. If somebody directly made a complaint, or if it's a police report, that's a chalan I was talking about, is being made before the court. And if the court, after taking cognizance, the magistrate feels no, there's no prima facie case against the accused, he's going to discharge the accused. You need to know what is meant by the term discharge. It's not proving innocence on the part of the accused. We are just releasing that person because we at this stage doesn't have any sufficient evidences against him. So whenever the fresh evidences will be there, he can again be convicted. This is what is meant by the term discharge. And if an acquittal, and let's make a difference between discharge and acquittal. Acquittal means you are acquitted. Now, there were no evidences against you. So there's a difference between discharge and acquittal. Discharge always happens before the framing of charges. An acquittal is something that comes only after framing of charges. So once the court feels no prima facie case, the court is going to discharge an accused. If the court feels yes, there is a prima facie case, looking at the evidences, because here this magistrate is not getting into detail of the evidences. It is the job of the court, fine, to appreciate the evidences in length. So he's just prima facie looking at the fact, the evidences produced, पुलिस रिपोर्ट जो पेश की गई है, जिसमें मेडिकल है, जिसमें स्टेटमेंट ऑफ विटनेसेस है, जिसमें सीज्ड मटेरियल है, all those things, they are just taking a cognizance of the same, and it can result in framing of charges also in case the magistrate is convinced there is a prima facie case against accused. And once the charges are framed, it will always result in the commencement of trial. Now, when we talk about trial, different courts conduct trials. Trial before court of session is there. Warrant cases, जहाँ serious cases होते हैं, उनको warrant cases कहा जाता है, punishable with death and life imprisonment, more than 2 years, and summon cases less than 2 years. And then we have summary trials. Summary trials are the trials which involve very less value of the property. 200 रुपए theft, आपने 200 रुपए की property का किया, stolen property of 200. So very summary trials, for very petty cases. But one thing is there that is common in summary trials, as the name is suggesting, is skipping some of the stages. You don't need to get into a lot of evidences because they're very petty offenses. But by and large, the stages which one can observe in the trials is the trial will always be conducted by public prosecutor or assistant public prosecutor, whichever is the case, if the depends on the court. The prosecution evidence is always recorded by the prosecution first. Evidence is always recorded by prosecution. Then comes a turn of defense. Then both the parties, bring arguments. And finally, on hearing the argument, the judgment is being given, resulting in conviction on the proof of guilt or a plea. If a person says, I'm ready to plead guilty, he can confess it before the court also. Or it will result in acquittal. So when the accused is proved to be innocent. And once judgment is pronounced, then comes your remedies for appeal, revision, reference. whenever there is no remedy of appeal, you can go for revision before the higher court. Sometimes the court is having a doubt on the legality of the question, or, whether this particular provision is really there or not, whether it has been overruled or not. So if they are having any doubt regarding any provision of law, any judgment, they can refer it before the higher court. So appeal, revision, reference, review, these are some remedies which are, review is basically its own judgment. So these remedies are there with the person once he's been convicted, and in case he's acquitted, then the remedies for the victims. Now, one very important thing is, that every trial which we are talking about needs to be very, very fair. From the perspective of accused, if we say, the CRPC does provides for the fair trial, all evidences to be recorded in the presence of accused. He should not be liable to subsequent conviction on the same facts once acquitted or convicted. He's given right to legal aid. ही इज गिवन राइट टू हर्ड ऑन द क्वेश्चन ऑफ सेंटेंस. किसी भी जजमेंट के प्रोनाउंस होने से पहले एक्यूज से पूछा जाता है, डज ही वांट टू से एनीथिंग ऑन द क्वेश्चन ऑफ सेंटेंस. And this is not just a formality that has been done by the court. The court has to make a genuine efforts to elicit a very, very relevant material which may be having a bearing on this question of sentence. So this is very mandatory section. Agar, if this is not being performed, it is performed in a mechanical manner, it can always be challenged before the higher court. So this is something very, very important provision with respect to, perspective of accused persons for ensuring the trial fair. In fact, being a criminal law teacher, I always find our criminal justice system very, very tilted towards the accused person. One can see lots of provisions from arrest till conclusion of trial. Fine, a lot of provisions are there in the favor of the accused person. But when it comes to the victims who needs to be fully rehabilitated, who needs justice in the way of, the person who has committed an offense against them should be convicted. But sometimes, situations are like the person who has committed an offense, he's absconded. वो पकड़ में ही नहीं आ रहा है. There is no sufficient evidences against him. We are not able to, make him guilty. So in that scenario, when we say from victim perspectives, a trial will be set to be fair when it will rehabilitate the needs of the victims and they'll be fully compensated. Then, these two conditions require one very important thing. First of all, conviction of an accused person. तो अगर accused है ही नहीं, he is absconded, so there is no conviction. Or evidences are not proved against him, there's no conviction. Or if the evidences are proved against him, he is convicted, compensation can never be out of the pocket of the accused person. So he will pay only whatever his pocket allows him. So we have in CRPC certain provisions which do talk about compensation to be given in the form of section 357, 357A, providing hospital opportunities to the facilities to the victims. All those sections have been there. But in case if somebody is not adequately compensated, and court also feels the same because this person was not having the financial capacity to pay, so in that case the court can always refer to the district legal service authority. There's under the Legal Service Authority Act, these authorities have been framed for the payment from state victim compensation schemes. Now, one very interesting thing, if I tell you, I wrote a paper on state compensation schemes. And if you look into state compensation schemes, you will find a lot of disparity in those compensation schemes. If I give you an example, if before we have come up with the victim compensation scheme these days, we have come up with it. Before that, I'm telling you the scenario. For rape, Delhi was providing the rape victim the maximum compensation of 5 lakhs. Initially, it used to be 3 lakhs, but then it was enhanced. If you look at Goa was providing 10 lakhs as a maximum compensation to the rape victim. If we were looking at Bihar, Jharkhand, it was just providing 25,000. So there was a lot of disparity, and there was a need to have a central victim compensation scheme because, some states are only recognizing 6 kinds of crimes where they are giving the compensation. Some are recognizing 8, some are recognizing 7. So one can see a lot of disparities there in such schemes. So there has always been a demand that there should be a central victim compensation scheme where everybody should be given a uniform amount to the victim should be given, because otherwise it will be becoming very unfair if a victim belongs to a particular state. So what has happened recently, the NALSA, that's the National Legal Service Authority, which is at the top. It with the central government has framed a compensation scheme for sexual assault, survivors of sexual assault or sexual crimes. And this has got approved by the Supreme Court in Nipun Saxena versus Union of India's judgment also. And now, if you will look at this compensation scheme for the sexual survivors, you will find for gang rape, the maximum compensation which they are giving is 10 lakhs, minimum is 4. For rape, it is 7 years maximum and 4 minimum. And for acid attacks, they are giving on the disfiguration of face, it is on the body 8 lakhs. So this is how the amounts are there, but at least they have come up with a central which is going to be applicable in all the states with respect to the survivors of sexual assaults. Fine. So at least that's a one initiative that has been taken in the protection of rights of the victims of sexual offenses. But still we need to have, as I said, that we need to have with respect to other offenses. यहाँ पे other crimes hai, but it is still covering the sexual offenses. So in case how one can approach under NALSA. So in case the court feels that compensation paid is not adequate, the court can refer the can sue moto, can ask the NALSA to consider the matter, District Legal Service Authority to consider the matter, State Legal Service Authority to consider this matter and provide appropriate compensation to this victim. Or sometimes the victim can herself approach the State Legal Service Authority for the compensation scheme under this particular scheme that has been approved by the Supreme Court. So that's the mechanism. So they will conduct inquiry, and they will be providing interim relief, which will be in the form of paying them the psychological expenses, meanwhile paying them their medical bills, and later on they'll be provided with maximum and minimum amount depending on the circumstances. And one very important thing recently, CRPC Amendment Bill 2020 has also introduced, proposed the concept of victim impact statement, which is very much prevalent in countries like USA, UK, Canada, very, very successful also. And what is this victim impact statement? At the time when a police report is being filed before the court, the proposal is with that police report, there should be also an extra of victim impact statement. Now, what will be that in a victim impact statement? Where the victim will be writing how the crime has affected him physically, financially, emotionally, psychologically, and what would be the purpose of filing this victim impact statement. Because at the time the court will be hearing the accused on the sentence of the question of sentence, there they have to also took into consideration this victim impact statement. So what is it? It's a check on the provision of providing fair opportunity to the accused. तो आप fair opportunity victim को भी provide कीजिए. Only then it will be considered to be a fair trial, when we are hearing both the parties on the question of the sentence. So you try to hear the story of the victim also, how this crime has affected the victim psychologically, physically, mentally, socially, economically, and then decide the quantum of the sentence. So it should not be one-sided only. So that's a wonderful initiative. In case it get introduced in India, definitely it will be a wonderful initiative. So it's still a proposal, but yes, we being a criminal law field, we really want this concept to get introduced in our CRPC. From witnesses perspective, if you are witness, be aware that till the Victims Protection Scheme was not being approved by Supreme Court recently, the kind of the protection which was available to you was only the police protection. There's no provision in CRPC dealing with any kind of protection to witness. In Delhi, we were having Neelam Katara's judgment, which laid down the guidelines for providing police protection, but that was only in context of offenses which were punishable with death or life imprisonment. And that too, after taking a lot of considerations in mind, nature of evidence, importance of witness, severity of sentence, all those things. But recently, we got a witness protection scheme approved by Supreme Court in Mahendra Chawla versus Union of India, which is prepared by, again, NALSA. NALSA has been very, very active, National Legal Service Authority. So along with central government, they have come up with this scheme, and it's identifying the witnesses on the basis of threat to their life and family members, threat to their safety, reputation, or property, and third kind of witnesses, which are who to whom the threat is moderate and extend to harassment and intimidation. So the kind of protection on the basis of identifying three categories of witness on threat perception report, which will be filed by the, if somebody is approaching the police. So one threat analysis report will be prepared by the superintendent police, and this report will be given before the state legal service authority or district legal service authority. And on the basis of that threat analysis report, that what kind of threat is there to the life of the victim or his family members, the kind of the protections will be provided. Now, what are the kinds of protections? This time we have moved ahead from police protection. So monitoring of mails and telephone calls, changing witness telephone number, installation of security devices, concealing their identities and referring them by change of name and alphabets, regular patrolling, temporary change of residence, escorting them to the courts on the dates of the hearings, and holding in camera trials, special arrangements, placing mirrors, screens, different passages for the witnesses and accused if possible, and conducting trials on day-to-day basis, and reallocation also. All these measures which today we have incorporated, they are basically the outcome of various consolidated legislations which one can see in Australia, Canada, and USA. They do go for this kind of protections. But the first time this issue was raised in Neelam Katara's, then the witness should also be provided similar kind of protection. In Neelam Katara case, the Supreme Court said no, we are not in position to provide such kind of protection because we have our financial constraints. So at that time, Supreme Court said whatever we can provide is it's just a police protection, and that too will depend on the considerations to be taken into consideration. But now at least we have made a beginning. To what extent we will be really successful in reallocating and providing them job opportunities, also change of identity, to what extent we'll be able to do so, that the time will come, but that will tell. But at least this initiative has been made, and initially this protection will be provided for 3 months, and then after review of again threat analysis report, the next course of action will be decided by the competent authority. Now, the last thing which I just want to discuss with you is, because in the beginning, I was just saying that despite of so many provisions in the CRPC, we have huge pendency of cases. And in this entire process, our right to speedy trial, which is a part of 21 of the Constitution, gets violated. And there is a very well-known maxim, justice delayed is justice denied. So in order to deal with that, and this is probably because of, I was saying, lack of infrastructural facilities, lack of the judges, number of judges are very less. So how to deal with it? If you look at CRPC, we have, I told you in the beginning, we do allow compounding of offenses. That is there under section 320, which results in acquittal, and one way it reduces dependency of cases. But can ADR be effective in criminal law as it is in civil law? So we have tried to incorporate ADRs, mediations happens, and plea bargaining was introduced as a formal mechanism for disposing of, for reducing the pendency of cases in the criminal law in 2005 amendment. And but though so far this plea bargaining is concerned, where a person pleads guilty, and in lieu of certain, he enters into bargaining with the prosecutor that I am ready to accept my guilt, but in lieu of this, my sentence should be reduced. So one thing you should always remember, that compounding of offenses will always result in acquittal of accused person. Plea bargaining, which is only applicable to offenses up to 7 years, one can't go for plea bargaining with respect to offenses against women, children under 14, socioeconomic offenses, it is not permissible. One can only plead, can go for bargaining to the extent of sentence bargaining. That is how it's applicable in India. It's in many forms: charge bargaining, fact bargaining, sentence bargaining. But in India, usually what does the court does, once the application is made, the court feels it is voluntary, the court gives the time to the parties to work out mutually satisfactory disposition. In case compensation is decided, the court will give the compensation also, but sentence will be given. And how the sentence will be given? Wherever there's a minimum punishment, it will give one half of the minimum punishment to an accused person. Where no minimum punishment is prescribed for any offense, then the court will going to give the 1/4 of the maximum punishment that is being prescribed. Court can also release somebody on probation also on the basis of his antecedent records and all. So that is how the plea bargaining is there. that is, but our courts have always been very reluctant in making use of plea bargaining, because the courts always have this tendency, the criminal law, the crime trials should be decided on the basis of merits, not on the basis of any kind of bargaining that is taking place between the prosecution and the accused person. But recently, there have been cases where the plea bargaining is being allowed, but the the way the USA, where it is very very successful, 90% of the cases are being disposed by the plea bargaining concept. Only 10% of the cases in India, they are being disposed with the help of plea bargaining. So we need to have effective ADR technology reforms in the criminal law in order to reduce the pendency of the cases in criminal law. And I think more light will be thrown by Dr. JP Meena when he'll be discussing. So he might be able to give you some more insight on the role of ADR in case he's covering in his presentation on criminal law. So with this, I would wind up my presentation. Thank you so much. Now the floor is open for the discussion. Any questions? Yeah.
Yes, if anyone have the question, please feel free to ask. If any doubt, whatever you have in the discussion.
Yeah, ma'am. I'm Naveen Mittal.
Ji.
Ma'am, I failed, I think, in I missed that point when you explained that compoundable or non-compoundable. Could you please explain it very briefly?
So there is a table, there is a section 320, which is providing for compounding of certain offenses which are less serious in nature. And if you look at 320, there are certain offenses only from the IPC that have been there, which are listed there. Some can be compounded with the parties themselves. No need to have a consent of the court, like hurt, simple hurt. You restrain somebody, wrongful restraint. But there are certain offenses like grievous hurt causing miscarriage, which can only be compounded with the permission of the court. So those compounding of offenses is permissible under 320, and the effect of that compounding would be the acquittal of accused person. And the compounding will happen only during the pendency of the trial. It can be before trial or during the pendency. But once somebody is being convicted and now you are going in an appeal, that is also a pendency. Once you get into an appeal, so that stage also it can be compounded, but not after that. So that is a concept of compounding of offenses under the CRPC.
No, ma'am. Actually, what is actually compounding? Is
Compromise. It's a settlement that is taking place between the parties, that we have compromised, we have resolved our matter. I don't want to go ahead with the this complaint any further. So the court in that case is going to quash the proceedings against that person.
Okay. It's clear. Yeah, it's clear. Okay.
Hello, Harlima, this is Preeti.
Yeah, Dr. Preeti.
Yeah. 3-4 सवाल सारे ही और जानने की इच्छा से हैं. एक तो ये मैम कि जब हमने ये कहा 0 FIR है एंड जुरिस्डिक्शन के इश्यूज जब भी आते हैं तो ट्रांसफर होने के लिए वी गो टू द नियरेस्ट पुलिस स्टेशन एंड वी से दैट 0 FIR प्लीज फाइल इट. उसके आगे के जो स्टेप्स हैं उसमें हमारा कोई रोल रहता है या वो ट्रांसफर अपने आप स्वतः होता है?
देखिए वो पुलिस ट्रांसफर करती है. वो पुलिस ट्रांसफर करती है. There are no rules in the CRPC related to 0 FIR. Every state has its own rule, but it is the concerned police station that has recorded a 0 FIR is going to transfer the same.
And there's the
The
turnaround
copy of
time
the
for
FIR,
this, ma'am?
Dr. PT, one thing is there. Even it is a 0 FIR, the copy of that FIR is going to be given to you, because you are entitled to get the copy of the FIR in any case. Fine. So even if it is a 0 FIR, the copy will be given to you. You can reach your concerned police station. But meanwhile, that particular police station is also going to transfer the 0 FIR to the concerned police station.
And is there a turnaround time, मैम, कि ये यहाँ से यहाँ ट्रांसफर होने के लिए इतना समय, क्योंकि बाकी सारा टाइमलाइन शायद वहीं से फिर आगे चलता होगा कि
तो सब कुछ ऑनलाइन है. अभी तो आपको बोला आजकल तो एवरीथिंग इज ऑन द वेबसाइट. सो आजकल तो ये दिस इज नॉट एन एक्सक्यूज. So it will take just a second to send it to a concerned police station.
Okay. Then मैम शुरुआत में हमने एक जगह एक शब्द यूज किया था कि आप प्रियम्बल देखा करें और उसमें कंसोलिडेटेड शब्द आता है यदि, एंड यू मेंशन कि एग्जॉस्टिव लॉज हैं ये. आई वाज जस्ट वंडरिंग कि क्या कुछ नॉन एग्जॉस्टिव लॉज भी हैं?
बिल्कुल
मतलब
है।
क्या अंतर है दोनों में, क्या अंतर होगा?
देखिए मैं आपको एक चीज बताती हूँ, आई जस्ट फॉरगॉट टू टेल यू दैट व्हेन यू लुक इनटू द सीआरपीसी, आई वाज सेइंग टेरिटोरियल एप्लीकेशन तो इसका इज एक्सटेंडेड टू होल ऑफ इंडिया, नाउ इट इज बीन एप्लीकेबल टू जम्मू कश्मीर आल्सो, and it is but not applicable to Nagaland and Assam because they have their own administration of justice act, so it's not applicable to Nagaland and Assam. But when we look into the general application of CRPC, I was saying that it has been made applicable to all offenses, local special laws. But at the same time, it is so flexible law in nature that it accommodates the procedures of the other laws also. How come one can see that? Because if you look at the POXO provides for friendly procedures. So there, wherever the POXO matter is coming under POXO, the CRPC procedures to be followed in the courts are not going to happen because we will be proceeding under POXO. Similarly, if our accused is a juvenile, so we will follow the procedure that is provided under the JJ Act. Fine. So that is how it's a language is used in such a manner that it itself definition says when they're defining bailable, non-bailable, the definition starts with this phrase, not with sending anything contained in the CRPC. So it's making one thing clear: whatever offense, whichever law you are looking into, try to look the nature of the offense in that particular enactment, because mere examination of the CRPC is not going to help you. Fine. But despite of that, we say that it says an exhaustive law so far when it comes to the procedures. Fine. Now, you have asked, are there any laws which are non-consolidated? Yes. If I talk about IPC, if you look at the preamble of the IPC has a 511 sections, fine. But still, I have not said it is a consolidated law because there are special laws also. Fine. We have a POXO, we have NDPS, we have FEMA, we have so many social welfare legislations. So IPC has not used anywhere consolidated. It is dealing with the offenses, some category of offenses, and there are other criminal offenses also under POXO, other enactments also. Similarly, if you will look at Transfer of Property Act, which deals with sale, mortgage, lease, exchange, fine. So the title says transfer of property, but the moment you look into that particular enactment, you will not get the procedure for the transfer of movable property. Now, movable property include goods also. So, which legislation now you have to see? You have to see Sales of Goods Act 1930. Fine. Similarly, you will look into the definition of immovable property in the transfer of property, which is using the word property. Whenever the word property is to be used, it is to be seen as movable and immovable. But ironically, it is only dealing with the immovable property, and for movable, you need to see Sales of Goods Act. But when you look into immovable also concept, that is not a complete definition. आप क्या देखते हैं? आप रजिस्ट्रेशन एक्ट में, क्योंकि प्रॉपर्टी खरीदेंगे तो रजिस्टर भी होगी, फिर आप रजिस्ट्रेशन एक्ट देखते हैं साथ में. क्यों? क्योंकि एक्ट ने तो क्लेम ही नहीं किया कि आई एम ए कंसोलिडेटेड एक्ट. सिमिलरली, you are getting the property transferred by the way of succession. So is this transfer of property will go on you, or succession law will go on you? It's a succession law that is going to govern you. So transfer of property can happen in so many ways. It's only when two parties, living parties, are being involved, and one is conferring a new title over the another, there comes in picture transfer of property. जब घर में पार्टीशन होता है, जब आपको कोई राइट मिलता है, प्रॉपर्टी मिलता है, तो वो क्या है? यू आर ऑलरेडी हैविंग एंटीसीडेंट राइट ओवर दैट प्रॉपर्टी. It is only after the partition it got separated and you got it, but you always had an interest in that share. So that doesn't need your transfer of property, which is dealing with creation of a new title. So that is how it is to be seen. So these are the examples. You can see your this transfer of property. IPC also doesn't say that I am a consolidated one. So that is all. So that's why I said आप company law देखिए, company law consolidated इस्तेमाल करेगा. So this is something very very relevant. I mean, whenever you're looking into law, please look into that.
एक तो मैम ये गुजारिश रहेगी, यदि आपके लिए संभव हो और आप ये पीपीटी शेयर कर सकें, बिकॉज फैंटास्टिकली मेड, वेरी एग्जॉस्टिव, तो हम लोग को नोट्स रिवाइज करने में मदद होगी, ऐसा समझिएगा.
I'll definitely share it. I'll definitely.
और ये अंतिम प्रश्न मेरा रहेगा मैम, हम लोग शिक्षा वाले हैं, जेंडर पढ़ाते हैं अक्सर, तो एक बहुत पर्टिनेंट इशू जब आपने फॉर एग्जांपल द वेरिएंसेस इन कॉम्पनसेशन अक्रॉस स्टेट्स वाला जब आपने बात किया, सो दिस वाज इक्वली न्यू एंड शॉकिंग फॉर अस. ये बस मैं आपसे जानना चाह रही थी कि हमने शुरू में जब ये कहा था कि सब्सटैंटिव, अर्थात जहां हम परिभाषित करने का कॉन्सेप्ट, अवधारणा बताने का प्रयत्न कर रहे हैं, प्रोसीजरल है जहां कैसे होगा, हाउ द मशीनरी, है ना? तो ये क्या कंपनसेशंस रहेंगी, कैसे होगा, ये स्टेट को अलाउड है करना, अर्थात ये परिभाषाओं से रिलेट ना होके प्रोसीजर से रिलेट हो रहा है? बिकॉज अगर ये परिभाषाओं से गवर्न होता तो शायद स्टेट्स को ये स्वायत्ता नहीं होती उतनी टू बी एबल टू
Dr. Preeti, एक बात है कि in criminal law you cannot have any straitjacket formulas so far when it comes to compensating somebody, because I told you it all depends on the circumstances, because new branches have come now these days, criminology, which says just don't focus on crime, please try to look at the criminal also, try to look into the background in which he committed the crime. Fine. So these days so many theories have been working behind. So I mean they cannot come up with one fixed and they need to see a lot of factors while giving the compensation, but because states have been given the discretion to come up with their policies, so on the basis of the funds which are being available and how they're allocating that budget towards particular compensation area, this is the issue. And that is why we say that there should be a central victim
Centralized.
compensation scheme, so that the center is contributing and is controlling them.
Thank you so much, ma'am. Thank you so
Thank
much.
you so much.
मैम एक स्मॉल क्वेश्चन मेरा है फिर नवीन.
जी.
आई एम फ्रॉम श्रीराम कॉलेज, आई एम टीचिंग इनकम टैक्स एक्ट. मैम सबसेक्शंस और क्लोजेस में कोई मतलब नाउ आई कैन इजीली टेल एज फार एज माय इनकम टैक्स एक्ट इज कंसर्न दैट वेदर इट इज सबसेक्शन और क्लोज, पर ऐसा कुछ है क्या क्राइटेरिया जिसमें फिक्स है
देखिए कोई
या
टर्मिनोलॉजी नहीं होती है. यूजुअली क्या होता है कि अगर आप मुझे शायद आर्टिकल या सेक्शंस में पूछते तो शायद मैं आपको बताती.
नहीं नहीं वो
आर्टिकल
भी
जो
बता
होते
दीजिए
हैं,
मैम, वो भी बता
आर्टिकल्स
दीजिए.
जो होते हैं वो जितने भी हमारे डॉक्यूमेंट्स ऑफ नेशनल इंपॉर्टेंस होते हैं, दे आर ऑलवेज यूजिंग द एक्सप्रेशन आर्टिकल. आप कॉन्स्टिट्यूशन देख लीजिए, आप यूएन कन्वेंशंस देख लीजिए, आप जितनी भी इंटरनेशनल ट्रीटीज देखेंगे आप उनमें आर्टिकल्स देखेंगे. इजंट इट? So whatever document is of lot of national importance, international importance, that will always be using the word article. But when you look at the word section or clauses, they are being limited to a particular law. Fine. And article is always a wider sense. सेक्शन जो होता है, सेक्शन आर्टिकल से कम वाइड होता है. आर्टिकल्स में स्कोप होता है सब क्लॉजेस को ऐड करने का. But so far section and clause is concerned, these are just terminologies different that have been used. In fact, agar I just wrote a book on JP while introducing me was telling that I wrote a book on surrogacy. It's finger. So when I was analyzing different bills of surrogacy till date, from the 2008 bill till 2020 bill, I noticed one thing, whenever the bills were getting changed, new drafts were coming, sometimes the legislature was using the word sections and sometimes they were using the word clause. So, I mean, it doesn't make any difference. Section and clause is same thing. It's just a matter of terminology, how they are using it. But yes, article and section is the difference is there.
नहीं मैम सेक्शन और क्लोजेस में तो इशू नहीं है कोई शायद.
Hmm.
मतलब आई डोंट थिंक देयर इज एनी इशू इन सेक्शन एंड क्लोजेस.
It's just
सब
a
सेक्शन और
terminology.
क्लोजेस.
Clauses are wide enough hota hai to include all other clauses also.
ओके मैम.
Okay.
Any other question anyone have? Please feel free to ask. I think that most of the question is already asked, answered in the
Criminal law
detail.
is so wide. I mean,
Okay.
we have to confine it somewhere. I mean, that's the thing that I was not able to cover so many things. But yes, I tried my best.
Yeah. So most of that is not easy. As a law teacher, I can understand that in the 1.5 hours, it's not easy to cover these detailed topic which we usually we teach in the 4-month semester. So that it was beautifully discussed by the Dr. Harleen, and it was very wonderful session. I will say that I'm sure that participants will be benefited, and I'm sure that by the question they are asking, it seems that they are very interesting and they found it interesting. So I'm thankful to the Dr. Haleen Kaur on behalf of that International Institute of Lifelong Learning and the Campus Law Center, and it was very nice experience to listen to her, ma'am. We will look forward to again in future occasions. So thank you so much, ma'am.
Thank you. Thank you so much.
Okay. So next session we will have at 4:30. So in meanwhile time we are taking 5 minute break. So we will start at sharp 4:30. Thank you.
All of you. JP, I'm audible?
Yes, you are audible. Your camera is off, I think.
Yeah, actually,
Okay. Network
yes,
problem issue. Yeah. Okay.
yeah. So, welcome from Institute of Lifelong Learning, University of Delhi. So, we are here for second session of the day with Prakash Meena. And let me introduce Prakash Meena. Prakash Meena, sir, is an assistant professor in Campus Law Center, Faculty of Law, University of Delhi. He has done his BA LLB honors from University of Rajasthan and LLM from National Academy of Legal Studies and Research, Nalsa University of Law, Hyderabad. He continued his academic interest and completed his post graduation diploma in labor laws. He has a number of publications, both in national as well as international journals. He has attended many national international seminars and conferences and workshops. Area of interest lies with the alternative dispute resolution, which is ADR, administrative law, constitutional law, and white collar crime. Over to you, JP sir.
Thank you, Dr. Arthi. Okay, so once we will start this session by this. I know that after the criminal law session, law of the crime session, now the total disputes. Now we are moving forward. Now we are resolving the disputes, and we will try that how you can settle some kind of the dispute outside the court also, and what are the benefit, what are the advantages in that, and how it is helpful in our current judicial system to resolve the problem. Okay, so what we are saying that you usually see that there are long pendency of the cases in Indian courts, and most of the time we say that tarik pe tarik, and this is the reality of the Indian judiciary system. So people do not prefer to approach to the court. Some hesitate to that कि नहीं वहाँ नहीं जाएंगे, थोड़ा सा सह लेंगे क्या होता है, ठीक है. Then people survive this. So this there is some kind of the mindset, but most of the time the people are not aware about this thing, that there are some mechanism which provide the resolution of the disputes outside the courts also, and that is very economical also, with time saving also, flexible process also. There are many advantages associated with that, but again, because of the lack of the knowledge and lack of awareness, that people are not aware about that. So today we are discussing the major. I will try to complete in all the things, but due to time constraint, I will also keep this thing also in mind. Okay, so alternative dispute resolution mechanism is a mechanism, alternative mechanism, which is the outside the court, is mechanism to resolve the dispute outside the court without the formal court hearing. Okay, so here there is no judge. The parties decide, and they, by their mutual consent, they decide the term of condition, and they decide the dispute. Okay, in a court system, what happened that one party lose and one party win. So again, if some parties agree by the decision of the court, then what they do, they will do that, they will file the appeal, and this is going on. So there is no final adjudication till that. But in this alternative dispute resolution, the win-win situation for all the parties. Okay, so the both no party feel that I lost. Okay, and that's why this is the known as the win-win situation. There is no ego. What usually happen in the court, that when one party lose in the court, there is some kind of the ego problem also. Okay, that I will see you in the higher court. So this situation is very not good. So to provide the solution of this, the alternative dispute resolution is there, where the win-win situation for the both the parties is there. Now it is also flexible. The parties themselves decide that how their dispute will be settled, what will be the term and conditions of their settlement. The court will not have do not have any kind of the role in that. So it is a very flexible thing there. Parties also decide that who will decide their dispute. Okay, what will be the term and conditions of that settlement, how it will be implemented, what will be the timeline to resolve the dispute, and these things. Now come to the time saving management. Again, I will say the Indian judiciary system, tarik pe tarik, but here what you will see, if someone refer to the ADR mechanism, you will find that the dispute is resolved in minimum time, which is less than the court procedure. Okay, there is no technicality, no formality issue, warrant, and all these things. Okay, so it is time saving. In the minimum time, your dispute is resolved. So this is the one. These are some kind of the advantages which are associated with these alternative dispute resolution. Now, the another thing is that these alternative dispute resolution mechanism is amicable and economical settlement of the dispute. So parties do not have to pay the huge fees of the court fees as well as the lawyer fees. Also, you can also save the parties can also save the fees of the lawyers again, and it is economical settlement of the dispute. So in the very less fees you can save that settle your dispute, and it will have the binding effect as it is a decision of the court. The second thing, another thing is the speedy disposal of the dispute. So the disputes which are decided by the alternative dispute mechanism is decided very at speed, okay, in a very less time. Confidentiality, this is the main attribute of this alternative dispute resolution mechanism, that the confidentiality of the parties will remain same. Okay, so what usually happen in the family matters, basically family matters are very small matters because it is settled at a very initial stage. But once the matter comes in the court, the parties take it, now it comes in the public forum. Now the लोगों ने देख लिया है, अब तो यही कोर्ट में आर या पार का होगा. लेकिन यहाँ पे द अल्टरनेटिव डिस्प्यूट रिजोल्यूशन मैकेनिज्म में what is interesting and what is the most good thing is the confidentiality, the privacy of the parties remain intact. So no third person who do not have any kind of the relation with the dispute is not remain present there. This is the one kind of the benefit in the alternative dispute resolution mechanism. The next thing is the court fees. So usually the whenever we file some kind of the suit in civil matters, the parties have to pay fees of some percentage in the court, as it is known as the court fees. For example, if someone party want to file the claim for the recovery of 1 crore and the court fees is 1%, then the party have to pay the one deposit 1 lakh in the civil court, and only after that the court will entertain these things. Okay, so this is the thing. But if some kind of the dispute arise, the parties, after some time the courts say that now we want to settle the dispute through the ADR mechanism, and the parties succeed. Okay, say so they decide they settle their dispute outside the court. In that situation, the court will issue the order of the refund of the court fees. So it is also the useful for the party. The parties also save the money, as well as they save the money, save the time, and all the resources, the human resources also. Because whenever the one dispute is comes in the court, it take the huge time of the court also. So this is also the one advantage which is associated with the court mechanism. Now we are moving forward. Now the question arises that why we need ADR in India. So if we take the data from the National Judicial Data Grid and the Supreme Court also, then we will find that there are 3.9 crore cases which are pending in the district and subordinate case courts. Okay, so if these huge cases are pending, and day by day we are seeing almost each day we court are witnessing the new cases. Okay, so this is the 3.9 crore data is 2 month back that data. You can also access this data from the National Judicial Data Grid. The dedicated website is available there. You will find that there are many cases. Some cases are pending for more than 30 years. Some cases are pending for more than 5 years. That is are mentioned there. And 58.5 lakh cases are pending in the various high courts, and more than 69,000 cases is pending in the Supreme Court. This is the reality of that. We have the huge pendency of the court cases, and it have to decide through the court. But again, due to, we can say that due to the less number of the judges, due to the court lack of the court infrastructure, many issue that is coming, and the very lengthy process of the judicial system is also the cause that why these cases are pending, and they are increasing day by day. So now we are not saying that this is the static data, this is increasing day by day. We also have to see this thing. Now, from that, there is section 89 in the code of the civil procedure. So basically the code of the civil procedure is provide the procedure for the deciding and settling the dispute, the civil matters. Okay, so this is a one section where it permits the in the law that you can settle the dispute outside the court. Okay, so according to section 89, where it appears to the court that there are exist element of the settlement which may be acceptable to the parties, the court shall formulate the terms of the settlement and give them to the parties for their observation. And after receiving the observation of the party, the court may reformulate the terms of the possible settlements and may refer the same for the arbitration or conciliation or judicial settlement, including settlement through lok adalat or mediation. So basically the section 89 is providing the four mechanism of the ADR, which is recognized by the section 89. The one is the arbitration, the second one is the conciliation, and third one is the judicial settlement. It may be personal, and it also include that settlement which is a pass made in by the through the lok adalat and the mediation. So these are the four. Okay, so as if I interpret this section 89, so basically what it want to say that if at any stage of the case, if case is already filed, case is pending before the court, and court comes to a conclusion during the pendency of the case, that there is some kind of the little hope is there that there may be the settlement and it may be acceptable to the parties, then court shall formulate the terms of the settlement and give the parties and before the referring the case to these ADR mechanism, court will know that what is the view of them. Okay, so what the court will provide the opportunity of hearing about that, whether they are interested or not. Okay, and after receiving the observation of the parties, the court may reformulate the term of the possible settlement as per their observation of the parties, and then in that situation the court may refer the case for the arbitration, conciliation, judicial settlement, including settlement through lok adalat and the mediation. So these formal process of the courts are there. Okay, so these four mechanisms are there. The section 89 is also providing the mechanism that for that. This is the first part of this section 89. So what basically it want to say that if there is a dispute which is pending before the court, then you can even there is even in that situation you can approach for the ADR mechanism. The parties can themselves also request कि हमारा dispute है, now we want to settle through the ADR outside court mechanism. Okay, so court may reformulate the terms of the possible settlement. So in the possible terms is that court give the time that this is we are giving the 3 months, for example, giving the 3 month time, then please discuss this, and this is the mechanism you want to adopt that. This will be the term and condition, and after 3 months, please convey what is your decision in that regard. So when we can pass the final order, that will be the binding on all the parties. Okay, whenever the court refers some kind of a dispute in the ADR mechanism, in the four mechanism, court do not control the process. It's the parties who control all these things. Okay, so parties are free, but in the court, before the court, parties are not free to decide. The parties are not free to choose that what kind of the decision they want, but in the ADR mechanism, parties are free to choose what is more convenient to them without the intervention of the court. Okay, and when you give the freedom to the party, then obviously there will be no appeal, because the parties mutually agree on some point of dispute. So there are major types of mechanism in ADR is the mediation, negotiation, conciliation, arbitration, and lok adalat. These are the basic major types of the alternative dispute resolution mechanism. So through five these, the dispute are decided, resolved outside the court. So it is not necessary that always that party first approach to the court and the courts refer the case for the ADR mechanism. No, even before the court, before coming to the court, parties are free to settle the dispute themselves through the help of the ADR mechanism. So there is no need to come approach to the court first. So okay, now coming to the next. Okay, so in mediation, what happened? In mediation, the parties in dispute refer their dispute to the third neutral person who facilitate party to arrive on some kind of the settlement of the dispute. Now, this third neutral person here in the mediation process is known as the mediator. Okay, so this is the mediator who facilitates the parties to come on some kind of the settlement of the dispute. Okay, so the role of mediator is limited to the facilitation. Okay, he will not compel to the party to that you must have to come on some kind of settlement. No, he is just facilitating the parties. For example, that he is uh, helping them, that if there is some kind of the confusion, then he will try to resolve. So most in most cases, the expert person are appointed as a mediator. For example, if there is some kind of the commercial matter, then some commercial expert, the expert in the commercial matter is appointed as a mediator. Okay, so suppose there's some kind of the dispute which is related to the family dispute. So someone who is an expert in the family law and family matters, who is appointed as a mediator. Again, the parties, it is the parties who choose the mediator, not the court. Okay, so if this is the mediation process, and this third neutral person is totally, it should be uh, free from any kind of the bias. Okay, it should not be related to the any of the party. Otherwise, what will happen, that one party will claim that this process was vitiated. Why? Because the mediator was non mediator was close to the other party, and because of that, this and what happened, which was not. So this is the mediation process. The third person, which is a neutral person, facilitate the parties to arrive on some kind of the settlement of dispute. It is always not necessary that always through the mediation the dispute will settle. There are some instances also there that mediation fails. Okay, and when it fails, when there is no settlement of the dispute for which it was referred to the mediation, so it will, we will say the mediation fails. And if they're there, and if in that situation, if the that dispute was referred for the in the mediation through the court as per the section 89 of the code of civil procedure, in the situation the mediation fails, then the dispute referred to the court at the stage where it was earlier before coming for the mediation. Okay, so what is the benefit of that? Now the court will start from the stage, from that stage it was referred for the mediation. So court again, it will save the time of the court. So court will not look it from the one point, from the start point. The another thing is also there. Sometimes the parties are free, that the parties not decide the sometimes there is a private session also, and parties say all the things in the mediation process, but there is a one condition is also exists, that whatever you are saying in the mediation process will remain private. Okay, so whatever is admitted by the party, suppose some party, one party is admit their own guilt. ओके कि हाँ मेरी कुछ गलती थी, पार्टी ने एग्री कर लिया, लेकिन बट सम हाउ रीजन द अदर पार्टी इज नॉट एग्री स्टिल, and what they say on the mediation fails. So now the statement which the parties say in the mediation process, that yes, I was guilty for some point of the time, that cannot be used in the court procedure. This is the one kind of the confidentiality in the mediation process. Okay, so the this mediation is more suitable for the family disputes. Okay, so usually the family disputes are decided in the referred in the mediation. And very famous example is that these we also seen that the Ayodhya dispute also it was also proposed by the Supreme Court that this dispute should be decided should be settled down through the mediation process. So it was also proposed by that. Okay, because it will take less time if that dispute is settled outside the court. It will be agreeable. It will be whatever the terms of the settlement comes in the mediation, it will be agreed by all the parties. So it basically it will be the win-win situation. So likewise, the most suitable, it is the most suitable form for the family dispute. It may be the matrimonial dispute, property dispute, personal disputes. Okay, so in these kind of the dispute, these mediation is used. For example, that if there is some kind of the dispute which is related to the distribution of the family property, and there are two brothers and they are fighting to each other on the property issue. So if you refer this dispute in the mediation process, okay, so what will happen that they comes, since that it is a private process, no third person is present, whatever they are the cause of real intention of the property dispute, they can express express it without any kind of the legal implication whatever is. And since they know that whatever they are saying here, it will not be disclosed to the third person, even not in the court, so they can say, they can express their emotions also. So the basically what in most of the disputes which involve some kind of the emotions, the mediation is the best method. And the family disputes are disputes which are connected with the some emotions. It is non-binding form of idea. So basically, if someone party not agree to settle the dispute through the mediation, once it is referred, then again it will fail. Then again it will comes to the court, and court will decide according to their own due process. Very recently, on 4 days ago, it was decided by the Union Law Minister that new law on mediation will be introduced in upcoming winter session of the Parliament. So basically, in India, right now, there is no law which is governing the mediation. Okay, so this is the only section 89 which provides some kind of the thing that yes, you can. This is the mediation is one mechanism to decide the settle the dispute outside the court, but there is no detailed law. And what is happening because of that, all there's some kind of the questions also arising, ambiguities also arising. But so basically the parties themselves decide that what will be the procedure of their dispute resolution, at what place they will settle the mediation procedure will take place, at what time, and through what medium, and what will be the implications. So the parties decide who will be mediator. It is also decided by the parties. Okay, so there is no one, if the it is decided by the parties, then now no, after that the parties cannot claim that he was the bias and all these things. However, his role of the mediator is just limited to the facilitate. Okay, not he is not the judge in the mediation process. वो एक person है, वो उनको एक facilitate करता है बस, वो वहाँ पर judge नहीं है. We have to remember this thing in the mediation. He just facilitate. Okay. Now come to the next mechanism which is available in the ADR mechanism is the negotiation. In negotiation process, the parties themselves sit together to settle the dispute without intervention of the third person. Okay, so like the mediation, there is a third person that is a mediator, but in this negotiation process, there is no third person. So the only party which is related to the dispute sit together and settle the dispute without intervention of the third person. It is informal process. Okay, it is non-binding form of the idea. If negotiation fails, then again the dispute referred to the court at a stage where it was earlier before coming for the negotiation or mediation. Now, arbitration. This is the only dispute ADR mechanism for which we have the India have the law, and that is the Arbitration and Conciliation Act 1996 that is governed by that. So the basically that arbitration is the adjudication of disputes by one or more specifically appointed expert who is known as arbitrator, settle dispute with the consent of the parties. Okay, so it is a adjudication. It is a quasi judicial. Okay, so what happen if suppose there is some kind of the dispute is there relating to some commercial matters. Parties say that this dispute arise, now we want to settle it through the outside the court. So for these such kind of the commercial dispute, business disputes, the arbitration is more suitable uh, form of the ADR mechanism to settle such kind of the disputes. Here the one or more person may be appointed as the arbitrator. Okay, so the adjudication is done by the arbitrator. Parties themselves decide or agree to refer their dispute, which is to be resolved through the arbitration clause. So what happens if the parties, okay, for example, there is some partnership, and parties in the partnership deed, the parties say that in case of any dispute arise, then relating to the partnership, that will be decided through the arbitration. Okay, so that clause in the partnership deed, or it may be in the contract, that clause is known as the arbitration clause. Okay, and if some party want to say that how it will be decided, and all the term and condition is settled, defined, that is the arbitration deed. Okay, so final outcome, whatever the decision of the arbitration is comes, is known as the arbitration award. It is also known as the arbitral award. It is very useful in the commercial dispute, business disputes, and all the thing. Why it is uh, it is more popular in the commercial dispute? Basically, the party that appoint the arbitrator, they know that what time the usually the court will takes time in the deciding, in the settling the dispute. It will be not serve the purpose of the for what purpose the dispute was the suit was instituted in the court. For example, there is a dispute regarding uh, of 10 crore, okay, and that dispute is pending in the court for more than 20 years in a court. Then basically the commercial organization do not want such kind of the pendency for they do not wait for more than 20 years. They want settlement within 6 months, 1 year. So here the arbitration is the one mode of the mechanism where they can say, okay, in this meanwhile time, 10 1 year the dispute will be settled, now we should refer. So they parties settle their dispute through uh, dispute. So you will see that there is a big corporate houses uh, preferring the arbitration. Because why? Because if there is some kind of the tax matter dispute, tax related dispute is there, that will be decided by the tax expert. So who is the expert in that subject area? Some dispute is related to company matter, then the whoever is the expert in company matters will be uh, appointed as the arbitrator, and it will be beneficial in understanding of the dispute and the settlement of the dispute. Next thing, parties themselves decide who will decide the dispute. Okay, so parties say that they say that for to be a to be a for the appointment of a arbitrator, what should be the qualification? It is again decided by the parties. Okay, they also decide that in how many times that dispute will be resolved. They also decide that what will be the procedure of the arbitration. Parties themselves decide, okay, कि क्या procedure होगा, in what manner the notice will be issued, in what manner the parties will appear, at what place the parties will appear, at what time parties will appear. Again, the parties are deciding themselves, and this is mentioned in the written form. So now no one can deny another party in later on कि no, it was not decided, it is already decided, the parties themselves decided. The next is the Lok Adalat. It is a form where dispute cases pending in the court of law or at pre-litigation stage are settled, compromised amicably with the mutual consent of the parties. It was the first time when the Lok Adalat was introduced in 1982 in Gujarat. The first time it was the, but after that, this after the popular and the usefulness of the Lok Adalat, this the concept of the Lok Adalat have been given statutory status under the Legal Service Authority Act 1987, which came into force on 9th November 1985. So all the provisions related to the Lok Adalat, that what will be the procedure of the Lok Adalat, what will be the composition of the Lok Adalat, what will be the decision of the Lok Adalat, and which kind of the dispute is to be decided by the Lok Adalat, all are discussed, all are explained, contained in the Legal Service Authorities Act 1987. So, and we also see sometimes the ad in the newspapers also, that we see the Lok Adalat are being organized at this place and this place. So the court, the Supreme Court is also encouraging the Lok Adalats, because they know that there are huge pendency of the cases, and if these cases are decided by these uh, general courts, then it will take long time. Okay, and this again it will increase the pendency. So that's the reason that why the Supreme Court again and again encouraging the Lok Adalat and the National Legal Service Authority NALSA, under these uh, guidance of these Lok Adalats being organized. So now the cases that which may be referred to the Lok Adalat, any case which is pending before any court may be referred to the Lok Adalat. Any dispute which has not been brought before any court and is likely to be filled before the court. As I said in very initially, that it is not necessary that always the parties come first to the court and the court refer the dispute to the ADR mechanism. Even before the coming to the court, parties may approach to the ADR mechanism. Okay, so it's not necessary that always time that party come before court first and then court will refer. No, it is not necessary. But there are some kind of the limitation. Any matters which is relating to an offense which is not compoundable under the law shall not be settled in the Lok Adalat. In earlier session by Dr. Harleen Kaur, where she explained that is what is the compoundable and non-compoundable. Okay, so compoundable in which the compromise is possible, and non-compoundable in which the compromise is not possible. It is mentioned in the law. Now you cannot settle. Okay, so the Lok Adalat settle the disputes only that is compoundable. If some matter, if offense is there, which is saying that it is non-compoundable, that it means that such kind of the dispute of cannot be referred to the Lok Adalat. This is the limitation. Why? This provision is have some specific reason. Okay, if something is not compoundable, it means it is a very serious nature of the offense. Okay, so the this is the why reason that why that it was not allowed to be settled through the Lok Adalats. Okay, otherwise it will be the violation of the rights of the victims. To protect the interest of the rights of the victim, this kind of the provision was inserted in this Legal Service Authority Act. So these cases, there are some kind of the cases which may be referred to the Lok Adalat, are the mutation of the land cases. You may refer such kind of in the Lok Adalat. Compoundable criminal offences. All criminal offences cannot be settled through the Lok Adalat. Please remember, it can be only the offences which are compoundable that can be resolved through the Lok Adalat. Family disputes, it may be decided, it may be settled by the Lok Adalat. Encroachment on forest land, such kind of the dispute also decided in the settled by the Lok Adalat. Land acquisition disputes, motor accident claims, cases which are not sub judice, which are not pending in any court. By sub judice means it's not pending in any court, that also may referred. Okay, again there are certain kind of the insurance claims. These list is not exhaustive. These are the major cases. Okay, insurance claim and all these things also decided in the referred in the lok adalas. Now come to the decision of the lok adalat. Every award, what the decision of the lok adalat will be known as the award. Okay, every award of the lok adalat shall be deemed to be a decree of the civil court. Okay, so it will have the same effect which the court have. Okay, so you cannot say that ये तो decision लोक अदालत ने settle करा था तो ये applicable नहीं है, enforceable नहीं है. No, it will have the same effect as it is of the normal court, general court. Okay, so every award of the lok adalat shall be deemed to be a decree of the civil court, or as the case may be, an order of any other court, and where a compromise or settlement has been arrived at by a lok adalat, the case referred to it under section 20 subsection 1, the court fees paid in such case shall be refunded in a manner which is provided in the Court Fees Act. This is the biggest advantage of the lok अदालत कि अगर आपका कॉम्प्रोमाइज हो जाता है, ठीक है, और वो लोक अदालत के थ्रू होता है, तो इस सिचुएशन में जो कोर्ट फीस आपने पे की थी एट द टाइम ऑफ द इंस्टीट्यूशन ऑफ द सूट in the very beginning in the court, it will be refunded. For example, if you want a recovery, you filed some kind of the suit for the recovery of 1 crore and you deposited the 1 lakh rupees, and the later on after the as per the provision of the section 89, the dispute was referred for to the lok adalat. In that situation, that entire court fees which was uh, deposited by the one party who bring the suit in the court, that will be refunded. Otherwise, otherwise in the normal process it will not be refunded. Okay, so this fees, the provision of the court fees is why is there, because to have some that to have the serious matters in the court. Otherwise, what will happen if you are not imposing any kind of the fees? Any everyone will comes to the court, and because they know that uh, they do not need to pay anything for that. So this is the court fees that is reasonable. It may vary from the state to state. I'm again saying it may be 1%, 0.50%, and all these things. And the next thing, that even award which is made by the lok adalat shall be final and binding on all the parties in the dispute, and no appeal shall lie to any court against the award. Okay, once it is decided and its dispute is settled through the lok adalat, it will be final and binding. Now the parties of the dispute cannot file further appeal against the decision of the decision of the lok adalat. So the no party is that. Why this kind of the provision is there? This to ensure to stop the litigation in the matter. Otherwise, what will happen? It will not serve the purpose of the lok adalat. Okay, and why this provision was added is that since the parties are coming the on compromise on settlement by mutual discussion, so down there is no scope that one party should file the appeal against the decision of the lok adalat. So this is why this is the provision is there. You must have heard about the national lok adalats in the various newspapers as well as the news channels also, that these national lok adalats are held at the national levels, held at the regular interval where on a single day. Okay, look, and throughout the country in all the courts, right from the Supreme Court till the taluk level, wherein cases are disposed of in huge numbers. Okay, so usually in the second Saturday of the month, the lok adalats are being organized, and for that detailed advertisement is also published in the newspapers and through other various media communication method. From February 2015, national lok adalats are being held on specific subject matters every month. Okay, more than 8.25 crore cases have been settled by this mechanism. Okay, so this through this mechanism, these cases already decided. These cases are addition to the pending cases, so please don't be get confused in that way. And this data is still to September 9 2015. So this show that what kind of, it also reflect the success of the national lok adalats, that how these national lok adalats help. Because why, uh, if some parties, you are giving the opportunity to the parties to settle their dispute, then they obviously they want, after some time they exhaust the court process and these all the things, so they want to settle the dispute, they comes from this. So this is the reason why this national lok adalats being organized. And it may be high court, as it is also organized at the supreme court level also, high court level also, district court level also, uh, subordinate court level also, taluk level also it is being held. Okay, there is one concept is also there, permanent lok adalats. So these national lok adalats what held, these are held in the each month, once in a month. But the permanent lok adalats are permanent in nature. They are sit like the normal courts. They have some kind of the disputes which are referred in that. For example, some kind of the telecom disputes, water bill disputes, insurance dispute, they are decided by the permanent law adalat. So there are various kinds of the mechanism is available in the alternative dispute resolution mechanism, which help us the parties to decide the settle the dispute outside the court, it with the some kind of the advantage. It has its own merits, no court fees, less time, less money, economical, mutually flexible process, and all these benefits are associated with all these things. So this is all about the resolution of the dispute mechanism, what I try to cover in this short time period, because I know that it's very I also have to keep in mind the time constraint also. So if anyone have any kind of a question, feel free to ask any kind of. Any question anyone any participant have related to this? No question?
Any
May
question
I?
for
Yes.
Actually, as you told, sir, there are so many law colors has been established to sort out the case at fast track. But even then, the pendency is very large. So, is there any solution to get the remedies very early stage when the case is filed?
Yes, there is some kind of the discussion is going on that where before the filing the suit case, that mediation is it was proposed that mediation should be mandatory in that situation. So before the coming to the filing, coming the parties coming to the court, they will be compelled to the go for the mediation process. So it was ongoing discussion, and that's why I'm sure that whenever these bill mediation law on the mediation will be uh, introduced in the upcoming session of the parliament, as was said by the law minister, I'm sure that such kind of the provision we will see in that things. This is the one solution in that. So there is no short term solution in that, because if we want to settle the clear the huge pendency of the cases by the current mechanism, then it will not be helpful in that way, because we will have to increase the number of the judges also. We will also have to increase the number of the courts also, and again it will takes time. It's not the one day task, so again it will takes time. So the solution is that if you uh, making mandatory these things, then it will be helpful for the settlement of the disputes. Yes, ma'am.
So, thank you, sir. And is there any possibility that the year of case has been passed? So, can it be settled out that it is 20 year or 30 year more than cases could not be heard now, and it is giving the one-time solution? Is that kind of possibilities also there?
Okay, so basically you want to ask that if some case is pending before for more than 30 years, so can whether such kind of the case can be settled through the ADR mechanism?
Yes, 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 yes.
Yes, there is. If the parties of the they file the application before the court at which that is pending, then the court will refer to, after due process, the court will refer the dispute to the ADR mechanism.
Yes, sir. That procedure is there even then the parties are ready. But suppose the parties are not existing actually, but the case is still pending.
If parties are still resisting, then there is no purpose of the referring to the case for the ADR mechanism. But however, still the court have the power, without the consent of the parties, court may refer to the dispute. But this is not preferred. Why? Because the ADR mechanism, the voluntary participation of the both the parties are required. If one party is not ready, then it will not be helpful. So in the most of the cases, it is not helpful. But yes, the court have the power to send the dispute to the ADR mechanism, even in the one party is registered for that, and one other another
Okay.
party is apply for that.
Thank you, sir. Thank you.
Yes, any other question? Okay, one question coming in the chat box. How can a dispute be resolved when that the case is believed to be related to a particular law of religion? Again, I'm saying that in the most of the ADR mechanism, if you see the Lok Adalat, only the compoundable cases are decided. Okay, so if some case is dispute is not compoundable, that cannot be decided. But again, some kind of the religion matter, like for the I think you want to refer for the Ayodhya disputes. So in that time, that Supreme Court also proposed that this should be decided outside the court. So again, the court will see that if there is little bit chance, slight chance in that way, that it can be settled through the outside court, then court uh, suggest or propose to the party that please, you may, if you want, you may settle the dispute through the ADR mechanism. It may be the mediation, it may be negotiation as per that dispute. Priya, any other question? Any other question?
I think no other question.
Yes, Ruchika ma'am.
Sir, just on a lighter note, the kind of disputes we have in the college among the faculty members or probably with the non-teaching staff at times, and then a committee is set up. So, is there any way to avoid such situations? Because ultimately it leads to a kind of ill feeling on both the parties, right? So, can we without just going into an official inquiry and all that, is there any way, so can we have a mediating committee?
Yes, you may have the it at your level also. So it's not necessary that before going to the court process that you should refer that. Even before the going to the court, you can settle the dispute, that dispute. But such kind of the dispute should be related to your. It should be eligible dispute. For example, if there is service matter dispute, because what happen in the usual disputes, that ego problems, when the ego problems comes in the courtroom procedure, in the court tussle,
Right.
it become very difficult to settle the dispute, and there is no ending process. But in the ADR mechanism, this ego problem is considered, and that's why the success of this is say that this is the win-win situation for the both the parties. So
Right, sir.
both the parties feel that they both the win, and this is how the dispute is resolved through that, and this is the way that why the people are trusting on this ADR mechanism today.
Yeah, thank you.
Any other last question anyone have want to have? Okay.
I think there is no other question. Unfortunately, I'm not able to switch on my camera. I don't know what is the reason. So, JP, can you hear me?
I can hear you. I can hear you.
Okay, so you really
Yes,
picked up
ma'am.
a very relevant topic, and mediation, obviously, because the courts are overburdened. So mediation is definitely is the future of settlement of the disputes, and it was a brilliant exposition. So on the behalf of all the participants, I extend my thanks to you for giving your valuable time and for the brilliant presentation. Thanks to you, and thanks to all the participants as well. Thank you. Thanks to all of you.
Thank you.
Okay, there is one formal announcement is also there, which is related to your course, is that there will be the one MCQ question paper through the Google form, and it will be circulated tomorrow after the fifth session, and it will be open for the 48 hours. The link for the Google form will be open for the 48 hours. So you people need to prepare with this. So whatever the resource person are discussing in their lectures, that questions will be asked in the session. This is the what I want to announce as a course coordinator. If anyone have the question relating to that, feel free to ask.
So, sir, this would be based only on the 5 sessions?
Yeah, there will that will only the first MCQ will be based on the first
Okay,
five,
acha, okay.
remaining after the 10th session.
Okay, so there would be another one.
Yes, so you will not be overburdened. Basically, you want to like courts
Okay,
are
thank
overburdened. We don't want to overburden you.
Okay, thank you, sir.
Any other anyone? Any question? Okay, I think that are all the question answered. So it's all about today. Thank you. Take care. Bye. See you tomorrow.
Thank you. Thank you, sir. Thank you.
Thank you, sir.